Question de preuve, épisode enregistré le 24 octobre 2019, raisins de la discorde, avec Dimitri Lascaris. Du studio Léo Laporte, je suis Hugo Martin, avocat en pratique privée depuis une vingtaine d'années et fondateur de Rivercast Media, une plateforme qui héberge des balados dont Question de preuve, un podcast d'actualité juridique. Aujourd'hui à Question de preuve, nous avons le plaisir d'accueillir Dimitri Lascaris, un avocat qui a commencé sa carrière au sein du cabinet d'avocats Sullivan & Cromwell à Wall Street et qui a un parcours des plus intéressants. Dimitri, welcome. Thank you for being here.
My pleasure. Thank you.
So we're just introducing you as a lawyer who started his career with the cabinet Sullivan & Cromwell at Wall Street. So can you tell me a little bit more about this?
Sure. I studied at the University of Toronto, and I was encouraged by a good friend of mine in my class at U of T to apply to Wall Street law firms because they were paying amounts of money, frankly, which were far beyond what was being paid by Bay Street law firms. And I was a highly indebted student, as was my friend. And so I applied to several firms down there. I'd never even been to New York City in my life. And I didn't know anything about the law firms. And so I got out this big Martindale-Hubbell directory to lawyers in New York City. And I picked,
as one does.
Yes, as one does. And I picked the law firms that occupied the most pages, thinking that they would be the ones offering the most jobs. And I sent off 10 resumes, and I got a number of interviews. And they flew me down into New York, and I remember they sent this limo out to the airport, and they took me to the UN Plaza Hotel. And when I came into Manhattan, I'd never been there before in my life. There were so many people in the streets moving so quickly that I thought there was a bomb scare. I said to the driver, "What's happening? There seems to be such an emergency." And he said, "This is New York, baby." And so I quickly learned that the pace in New York City is very different from what I was accustomed to.
I'm kind of sorry that I asked you to take a taxi to the studio, and I didn't send a limo. Yeah, maybe next time. So Sullivan Cromwell, what were they doing, or are they specialized in anything, and what were you doing there?
Well, they serve corporate clients, high net worth individuals, I'd say almost exclusively. So when I got there, I wanted to be a litigator and work in their corporate litigation department. But I soon learned that if I remained a litigator, I wouldn't be able to work in one of their foreign offices, and I really wanted to go to Paris. So after 6 months, I switched into the corporate securities program, hoping that they would allow me to transfer to Paris. And I advised mostly investment banks. Our biggest client was Goldman Sachs. I did a lot of securities offerings for Goldman Sachs. And in my third year, I was rewarded with my switch to corporate securities with a transfer to the Paris office, and I worked there for 2 years, mostly with sovereign issuers like the German development bank, Kreditanstalt für Wiederaufbau. For the Bank of Greece, I did their maiden bond offering in the United States. But after 4 years of doing that, 2 in New York and 2 in Paris, I realized that really wasn't a particularly satisfying practice of law for me.
Oh, really? Okay.
And I left the legal profession for a few years.
Okay, that's very interesting, especially with the le parcours, so the cheminement that you've done from where you were to right now. It's kind of like a full circle, basically, from like really high-end with a lot of money to a little bit more activist, I would say, and I guess less money coming in.
Well, most of the work I do now is pro bono, and I do that in part because I feel like I was very fortunate to be paid what I was paid as a securities lawyer and as a class actions lawyer later on. And this is a way in which I feel I can give back to the community and show my appreciation for my good fortune, because I have been very fortunate in my career. No doubt about it.
2012, Canadian Lawyer Magazine classified you, if I could use that word, as one of the 25 most influential lawyers in Canada. So how did that come about?
Well, I think it was primarily because of the fact that the firm where I came back to Ontario after years away from the practice of law and joined Siskins, a leading class actions law firm. And at the time, there was pretty much no one in Canada who was suing public companies for securities fraud. It was a very new and developing field of law where you had to overcome considerable obstacles in order to obtain relief, and very few lawyers were willing to take on the risks of these cases. And Siskins, because I was a securities lawyer, said they saw an opportunity to begin to develop this practice area, and they gave me all the resources that I needed, and eventually I was able to hire, I think I had over 10 lawyers on my team. I had a staff of 15 people. And it grew to be the largest securities class actions team in Canada, and we probably filed and prosecuted something like 75% of the securities class actions in the country from 2007 to 2012. So I think that...
name a few.
Well, we sued Research in Motion for stock options backdating, a company called Baffinland, ArcelorMittal we sued in connection with the takeover of a Canadian iron ore maker. Molson's we sued. We sued Sino Forest was a major forestry company that was listed on the Toronto Stock Exchange and went bankrupt. And we went after the auditors in that case, amongst others, and we got a settlement of $110 million.
So you made a lot of friends.
The corporate community was, I don't think they were enamored of me and my colleagues at Siskins, but I know that the Bay Street bar was quite fond of us because we gave them a lot of work. So that's something a sentiment they often shared with me.
A little later, Canadian Business Magazine, je veux dire en français, le défenseur le plus acharné des droits des actionnaires. So that was a motivation for you?
Yeah, when I was working at Sullivan & Cromwell, I saw it was a privilege to work there. It was a great education for me as a practicing lawyer. But I also saw that, the wealthiest members of society and large corporations have almost exclusive access to the finest lawyers that money can buy. And that creates injustice in our society. That creates particularly injustice in the capital markets, where investors are regularly being fleeced and they don't have any recourse, any real opportunity to recover compensation for their losses when they've been wronged. And so Siskins presented me with an opportunity to right that wrong, or at least try to help righting that wrong. And I'd like to think that, we helped to impose a certain level of discipline on Canadian capital markets that didn't exist previously. And I think it was in 2004, the governor of the Bank of Canada, David Dodge, he described the securities markets in Canada as the Wild West. And I think that's a fair characterization. There was relatively little in the way of real enforcement against large companies that were violating the securities laws. There's fairly vigorous enforcement in Canada.
He's now in the UK, and I don't think it's any better over there.
Not in the UK.
That's Mark Carney.
Oh, that was Mark Carney? Okay.
Yeah, he's the governor of the Bank of England. He's not really charged, I think, with enforcing the UK securities laws, but there's very poor enforcement in the United Kingdom as well. The gold standard had been established, many thought, by the Securities and Exchange Commission in the United States. It certainly was the most vigorous enforcer, but after the financial crisis, we realized that even the Securities and Exchange Commission isn't particularly vigorous about going after large, well-capitalized corporations that commit securities fraud.
How do you navigate between like the rights of smaller investors, smaller shareholders, and the rights of the big shareholders that sometimes they do benefit from those big corporate reorganization, or they're part of the administration of the company, or how do you navigate this?
Well, it's a very important question you ask, because it sheds light on what is actually happening in the capital markets. It's a rare the institutional investors, the non-union institutional investors. So they're union pension funds,
correct,
and they have a fairly different attitude, which I'll get back to. But then there are the banks and their subsidiaries managing various funds that hold very large positions in public companies in this country. They will not sue. They almost religiously avoid acting as plaintiffs in securities class actions
because they're involved in so many. It's a wheel. They're scared that it's going to come back.
They don't want to alienate the corporate class. And a lot of these people, eventually they might leave this particular fund where they're managing money, millions of dollars, and go off and work in the executive suites of some corporation. They don't want to make any enemies. That's the reality. So they don't act as plaintiffs. They religiously avoid doing that. Union pension funds, on the other hand, are quite willing to do that. And small investors were the most active litigants in securities class actions. And so you have this perverse situation where the shareholders that are losing the most money because they have the largest positions in these corporations are not carrying the burden of acting as litigants in class actions. That's being done by individuals and smaller union pension funds. They benefit to a greater degree than anybody because of the size of their positions, but they won't take on the burdens of acting as a representative plaintiff. And the burdens aren't even that particularly onerous. You simply have to instruct your counsel from time to time and remain engaged in the litigation. But you don't have to devote hundreds of hours of your time to be a plaintiff in a securities class action.
So you did tell us that after a while you've realized that maybe it's not something for you. You were very fortunate, I understand, with the salaries and what came back to you, and you started getting involved in more. I
retired from the Partnership of Siskins at the end of 2015, and for 6 months I was a consultant to help them transition to new leadership in the securities class actions team. And then in mid-2016, I left I wouldn't say I left the practice of law, I left the business of law, and I stopped taking compensation to be a lawyer. And I began to do individual human rights-related litigation on a pro bono basis. And I've been doing that ever since, and I think it consumes probably about 500 to 1,000 hours of time a year. So it's not really a full-time job. Mm-hmm. It's not nearly as demanding as my securities class actions practice was. But it enables me to represent people who don't.
You should try podcasting.
That thought has occurred to me, actually. Maybe you can help me with there. So this is something that is very satisfying to me, very gratifying, and in many ways I enjoyed a lot more than being a securities class actions lawyer.
I know that you were president of the Canadians for Justice and Peace in the Middle East.
Yeah.
Can you tell us a little bit more about this?
Well, this is an organization which was co-founded by a gentleman by the name of Thomas Woodley, who's he's currently the CEO of the organization, and they are, as the name suggests, concerned with advocating for peaceful solutions to conflict in the Middle East. And one of the areas, the regions that they're particularly focused on are Israel and Palestine. And because of my work in the Palestinian Solidarity Movement, I got to know Tom Woodley, and he asked me to become chair of the board. And I happily accepted. It's a wonderful organization, but due to time constraints, I've moved on from doing that. I continue to be a supporter of the organization, though, and it's something that I think everybody should look at carefully because they deserve our support at CJPME.
And again, I guess lending your time as well, you decided to make a move to politics with the Green Party.
Yeah.
And where you're still part of the organization today, I understand.
Well, it's a little bit more complicated than that. Yeah, I ran for the Green Party of Canada in the 2015 election in the riding of London West. I lost by a substantial margin, and so I did it not thinking.
You could have just said lost.
No, well, crushed would be a more accurate description. But I didn't really anticipate I was going to win, and I mean, London West, no Green Party candidate had ever gotten even 10% of the vote, so it was a long shot. But I thought it would give me some insight into what it's like to be a candidate, and also that it would provide me with an opportunity to force the candidates to talk about climate change. And that was the dominant theme. And I took part in all of the all candidates debates, and I was constantly harping upon climate change. So I felt that there was a shift in the conversation during the campaign. And I'd like to think that I contributed to the defeat of the conservative incumbent, who was the Minister for Science and Technology, Ed Holder. And a liberal emerged victorious, Kate Young, in that. So after that, it was an experiment for me. I don't know if I'll ever run again. I certainly was not interested in doing that in this election. But as a result of that, Elizabeth May, the leader of the Green Party of Canada, 3 months after the election, asked me to become a member of the shadow cabinet of the Green Party. And I accepted, and I assumed the post of justice critic. And then we can get into this later, perhaps, but 6 months later, she and I had a falling out, so I ceased to be a member of the shadow cabinet, and I'm currently in the shadow cabinet of the Green Party of Quebec. So I'm not affiliated with a federal party. But Alex Terrell asked me to assume the same position within the Green Party of Quebec shadow cabinet, justice critic.
Oh, thank you. So if we jump into the thick of the subject, let's say, so what happened is, I go through Twitter all the time, and decisions, and I look around, and I like wine, like a lot of people, like a lot of lawyers, and I see the decision, Kattenburg v. Canada, and start being interested because it was a labeling issue. So basically what I saw is that, there's a mislabeling, there's a wine that was not made in Israel with an Israeli label. But that was the only thing. So then I tell James, notre recherchiste, I say, James, let's look into this and let's see what's happening. And we felt like we opened a can of worms. First of all, Dimitri Lascaris, you have a fairly good amount of articles written about you, on you, for you, against you. We have our current PM that also made some comments about you. So we got all this going on, and at the same time, there's the always the background issue of Palestinian, the occupied territory, the West Bank, and Israel, and you know, then I see, okay, why Lascaris and why Kattenburg? Like it's not something that would have a natural reflex of, okay, those two guys going against a Israeli label in a Canadian court. So tell us a little bit about the genesis of Kattenburg v. Canada.
So up until 2016, when I joined the Green Party shadow cabinet, I really wasn't active in the Palestinian solidarity movement at all. I think if you asked activists, you know, in the early 2016, who's this guy Lascaris, nobody would have known me in the community of Palestinian solidarity activists. It was an issue that I cared about, but it was not something that preoccupied much of my time. And then purely by chance, within about a month of my becoming a member of the shadow cabinet in 2016, I had to go to Israel. At that point, I was transitioning away from class actions work, and one of the cases that I was doing was against a Canadian gold mining company called Nevsun, which was alleged to have used slave labor in Eritrea, which is a deeply repressive country. And many of these slave laborers had ended up in Israel. They had escaped Eritrea, and they were in Israel, and I had to go there to interview them about what they experienced at this mine in Eritrea.
So the plot thickens.
Yeah,
so when I said we opened a can of worms, this is brand new information that we haven't even dug into.
Yeah. It's a horrific story, and it's really quite sheds a great deal of light on what is actually happening in the mining sector. But that's a whole other story in this country.
Another episode coming, maybe.
Happy to talk about it. It's one that has to be talked about more. The extractive sector is doing terrible things abroad. But in any event, I went there to interview a number of people, and I had a friend, Palestinian-Canadian artist by the name of Rehab Nazal, who at the time was in Bethlehem, and she splits her time between Bethlehem and Canada, and 6 months earlier she had been shot by an Israeli sniper in Bethlehem while she was taking photographs of an Israeli skunk truck, which is a vehicle which spews noxious fumes on the homes of Palestinians to keep them from coming out into the streets. And so she was shot. And I went there. She said, I want you to see what happened, to see the site of the crime, and I want to take you around the West Bank and show you how we live. And over 4 or 5 days, I went all over the West Bank with her, and I was so horrified by what I saw that when I came back, I felt, as a matter of conscience, I had to do something. And my thought was to bring forward a resolution within the Green Party calling for the party to support the use of boycott, divestment, and sanctions to end the occupation. Can you? I'm
sure you said it, but can you situate us in time? So, what year was that? 2016, is that?
That was 2016. So that was around March that I went to Israel, and I came back in April, and I brought forward this resolution. And one of the first things I did was I asked Elizabeth May if she would support the resolution, and she flatly refused. She said,
just, "Sorry for interrupting, but explain to us quickly what this movement calls for."
Sure. The
title basically says it.
BDS, boycott, divestment, and sanctions, has 3 goals. The first goal is to end the occupation of Palestinian territory. The second goal is to ensure that Palestinian refugees are enabled to return to their homeland. They have that right under international law, but they've been deprived of that right for decades. And the third is to ensure that Palestinians living within the state of Israel are treated equally, because they're not. They're second-class citizens. My resolution only dealt with one of those 3 goals. It only dealt with the occupation. It didn't address the other 2 issues. So it was a very narrow, modest proposal, I thought. But Elizabeth May flatly refused to support it because many people who support Israel have falsely characterized the BDS movement as being anti-Semitic. That's simply not true. It's, in fact, a gross falsehood. It is anti-racist in every sense of the word, the BDS movement. It's absolutely opposed to all forms of racism, including anti-Semitism. And I think Elizabeth understands that, but Elizabeth was concerned about perception.
Yes,
Correct.
there's
yes.
political implication
Yes.
to supporting. Fortunately or not, I'm not passing any judgment, but there are political implications. I'm sure, Dimitri, that you were aware of those as well.
Yes. So I wasn't particularly surprised. I was a little bit disappointed, but I wasn't particularly surprised when she said she wouldn't support it. But I felt as a matter of conscience that I had to continue down that path. And when she declared to me that she was not going to support it, I thought we were going to lose. I thought there's no way I'm going to be able to persuade the majority of the members of this party to support a resolution which this wildly popular leader has flatly refused to support. And much to my surprise, at the convention in August of 2016, where we debated this, and Elizabeth May put considerable effort into defeating the resolution, a large majority of the members adopted it over her objection. And the next day, she threatened on national television on the CBC to resign. And so the party federal council reacted with considerable concern and hastily organized another convention. This is something which was virtually unprecedented in Green Party history, to take place 3 months later in Calgary, where we would revisit this resolution. And it was very clear that the goal was to have it repealed in order to persuade Elizabeth to remain the leader. And in that period, a bunch of people within the Green Party came together to defend the resolution, and one of them was Dr. David Kattenburg, a wonderful human being, a science educator, a child of Holocaust survivors, a vigorous, passionate defender of Palestinian rights. He played an important role behind the scenes in helping us to preserve. Actually, we emerged with an even stronger resolution at the end of the day, but it didn't have the acronym BDS in it. Mm-hmm. So cosmetically, it seemed to be different, but in fact, it was even a stronger resolution. So I guess, the result of all of that was that we all felt really excited. We thought, wow, what we can do with activism, what we can do when we come together. And David said, we got to take on another battle. And I want to go after these settlement wines. And I said, what are you talking about? He said, there are wines being produced in Israel's illegal settlements and being sold in Canada with Product of Israel labels on them.
So the spark for your activism career or career as an activist started at that convention.
I would say that it actually started a little early. The climate crisis was something that I had become very engaged in, and I took part in some civil disobedience relating to the climate crisis in 2015.
So you have a whole debacle with the DBS, and then you have that wonderful gentleman, science educator, who's telling you, no, I have an even bigger fight. I want to talk about wines.
Exactly. And the issue for him was the labeling.
Yes.
Because the labeling was fraudulent, and he felt that this was just an affront to international law, because the international community is virtually unanimous that the West Bank is not part of Israel, even Israel itself.
So I'm going to stop you right now for our listeners. So just tell us right away. So the labeling, I know I talked about it a little bit in my intro, but the labeling of the wines, just and then we can continue with how it started with. But what was the problem with the labeling of the wine, according to Mr. Kattenburg?
Well, the wines are actually produced in the West Bank, and the West Bank is not part of the sovereign state of Israel. It is occupied Palestinian territory, and that is absolutely clear in international law.
Correct.
And so he said these wines are falsely labeled. You have to have accurate country of origin labels on your wines. That's required by the Canadian Food Inspection Agency and by the pertinent regulations. And so I'm going to complain to the LCBO.
So he tells you this,
yeah,
I hope over a glass of wine?
Sure it was over several glasses of wine, but he exactly. Well, we hope so. It said Bordeaux on the bottle, but anyways, so I didn't really have much of a role in it at the outset. I mean, we talked about it. He told me what he wanted to do. I shared some thoughts with him, and then he went off and he did it.
Did you know anything about Canadian labeling laws or
no? No, I knew only that they had the country of origin labels have to be accurate.
Yeah, just as anybody would know that an Italian wine must come from Italy.
Correct. But I had no prior experience in this area. So during the next 6 months, that was January of 2017. He complains to the LCBO. He's ignored for 3 months. He starts getting frustrated.
So when you say complaint to the LCBO, I just want to make sure. So he did send, and this is in the summary that James provided to me, he sent a letter to the LCBO in January 2017.
Correct.
And that letter
he
remained unanswered. So.
He identified the two wines, explained that Canada's position, which anybody can confirm by going to the Global Affairs website, is that the West Bank is not part of Israel. It's occupied Palestinian territory.
There were two wines sold at the LCBO. One was Shiloh Legend, 2012, and Psagot Winery M Series Chardonnay, 2015.
Correct.
So these two, there might have been others, but these two were sold at the LCBO with a label Israel, but they were produced. Yeah.
And Psagot, you mentioned Psagot Winery. Psagot is a settlement which is just outside of Ramallah. And it basically cuts off Ramallah's access to much of the rest of the West Bank. And Shiloh is another settlement in the West Bank. And so he picked these two wines, and he sends this letter to the Liquor Control Board of Ontario. After 3 months of silence, he demanded to know what was going on, and then they revealed to him that they had basically thrown up their hands and said, we're passing the buck here. We need to go to the Canadian Food Inspection Agency, which is a federal agency, and ask them for their guidance.
Yeah, so on March 31st, 2017, Mr. Kattenburg goes straight to the Canadian Food and
Inspection Agency, the CFIA.
Yeah. So the Canadian Food Inspection Agency, l'Agence canadienne d'inspection des aliments.
Right.
And just talks about a problem with the labeling, that nothing special.
He essentially communicated directly to them the same complaint that he had communicated to the LCBO. And so another 3 months go by, approximately, 4 months. And he actually went off to the West Bank during that period as part of his admirable activism. And immediately upon his return, he discovered from the Facebook page of B'nai B'rith Canada that the LCBO had just delivered a letter to all of the wine vendors in Ontario instructing them to remove these two wines from the shelves and directing them not to allow these wines to be sold in Canada with Product of Israel labels. And B'nai B'rith, we don't know to this very day how B'nai B'rith got a copy of this letter before Dr. Kattenburg was even informed of it. The complainant himself didn't know, but B'nai B'rith did. And B'nai B'rith said, we're shocked and appalled that this has been done, and we're doing everything we can to get the CFIA to reverse itself. And then 6 hours later, it posts another statement on its Facebook page saying, we expect this appalling decision to be overturned shortly. We have sources within the government who tell us it's going to be overturned. And sure enough, within 24 hours of the first Facebook post, and within a matter of days of the LCBO instructing its wine vendors to stop selling these wines, the CFIA reverses itself. And the explanation it gave was rather cryptic. What it referred to a particular article of the Canada-Israel Free Trade Agreement, which defines this territory of Israel for purposes of that agreement as being the area where Israel applies its customs laws. And the reasoning of the CFIA was Israel applies its customs laws in the West Bank. Even though the West Bank is not part of Israel, therefore, these labels are in fact accurate because this is how Israel is defined under the Free Trade Agreement. At that point, David hires me. He asked me whether I would represent him, and I agreed to do that on a pro bono basis. And our first course of action was to file a complaint with the Complaints and Appeals Office of the CFIA. Within 3 or 4 weeks, they adjudicated that complaint, rejected it. They did agree that it was wrong for Mr. Kattenburg not to have been informed of the decision before it became public. But beyond that, they weren't prepared to criticize. The justification for reversing the decision was the Canada-Israel Free Trade Agreement.
Okay, so
and this definition of the territory of Israel. So after the Complaints and Appeals Office rejected his appeal, then we filed an application in the Federal Court of Canada for judicial review. And the judge who presided over that application is Justice McTavish, who was the head of the Canadian Human Rights Tribunal. And she's now been elevated to the Federal Court of Appeal. And she rendered her decision in January of this year, and she agreed with Dr. Kattenburg that, in fact, these labels are false, misleading, and deceptive because the whole world regards the West Bank as being occupied Palestinian territory, and not even Israel regards the West Bank as being part of its sovereign territory. So I think for her, it was a very straightforward decision. She asked every single participant in the courtroom, and in addition to ourselves and the lawyers for the Attorney General, there were 2 interveners, B'nai B'rith Canada and Independent Jewish Voices, which is a wonderful organization that advocates for Palestinian rights. And she asked all the counsel in the courtroom, do you take the position that the West Bank is not part of the state of Israel? And everybody concurred. And I think she felt at that point, quite rightly, that the only conclusion she could come to was that these labels were false, misleading, and deceptive.
It's 29 pages decision, and when you read the summary, and by the way, all the links, all the necessary links are going to be available to our listeners on the website and on the podcast page. But when you read the summary, one of the things that comes out and like straight in my face was the territory itself was never an argument, was not even contested.
Correct.
And using l'accord de libre-échange Canada-israélien qui dit que le territoire d'Israël s'entend du territoire où la législation douanière d'Israël s'applique. Mm-hmm. So that was the defendant's, let's say, argument.
Yes, that's one of their arguments. They had others which I think we should talk about because they're quite revealing about the government's attitude towards this whole issue.
I think we should as well.
Yeah.
One of them is pretty good that I read about. Was I think it was one of the prosecutors who said if Canadians want to know where their wine is from, they can just check on Google.
Yes, that was one of their arguments.
Yeah, one of the arguments was just Google it, basically.
Yes, but it's preposterous. I mean, we all know when you walk into a grocery store or a wine store and you're looking at the labels on these products, you don't have time to Google search to determine whether or not these products are accurately labeled or not. You trust that they are accurately labeled and that the government's doing its job and is ensuring that they're accurately labeled. Who goes into stores, looks at products with various country of origin labels, and then starts doing Google searches before they make their purchase? Who has the time to do that? Who has the inclination to do that?
But that's why there's labeling laws.
Exactly.
To make sure that
precisely
you don't have to do any of these things.
Yeah, if it's caveat emptor and it's a jungle out there, then everybody is at risk, and we would all be expending enormous amounts of time and energy doing due diligence.
So why such a simple matter became a matter where l'accord de libre-échange Canada-Israël was part of the applicable legislation that was submitted, la loi sur les emballages et l'étiquetage des produits de consommation, la loi sur les aliments et drogues, la 4e Convention de Genève, la loi sur les conventions de Genève, la Charte des Nations Unies. So all this was raised at trial.
Correct. So the one I think really we should talk with, two of those things I think merit discussion. The first is that the Canadian government itself has acknowledged for decades that the settlements violate the Fourth Geneva Convention. And in a particular Article 49, which has a prohibition on the transfer of an occupier's domestic population to the occupied territory. Not only is that a violation of the Fourth Geneva Convention, it's a war crime under the International Criminal Court Rome Statute. And there's a provision in the Fourth Geneva Convention, Article 1, which requires the parties to the convention, which include Canada and Israel, not only to respect the convention themselves, but also to ensure that other parties respect the convention. And so our argument was that Canada, by allowing these wines to be falsely labeled, is in fact facilitating the violation of the Fourth Geneva Convention by these settlers, these Israeli settlers. So Canada is violating Article 1 by taking the position it has taken. So that was one of the arguments we made. The other argument that we had to respond to was not one we made, and this was, for me as a citizen, I was quite offended that the government was making this argument. They claimed that consumer protection laws in this country, the federal consumer protection laws, only relate to things that affect your physical health. So, for example, if you are interested in animal rights and there's a representation made by the producer that their livestock is being treated in a humane way, but it turns out that they're torturing these animals and they're treating them in the most barbaric manner imaginable. Under the government's argument, you as a consumer who cares deeply about animal rights would have no recourse under federal law.
Because you're not personally harmed by that.
Exactly.
Okay.
And to give you one more example, let's suppose that you care deeply about the climate crisis and you don't want to buy products that are made 2,000 miles away because of the carbon emissions involved in transporting them. You want to buy locally produced goods, and some producer lies to you and says the product was made locally, but it was made in Asia. Okay. According to the government, you have no recourse under federal law. Thankfully, and I think this is one of the wonderful parts of this decision, and it goes way beyond the whole conflict between Israelis and Palestinians, the court rejected this argument and said, no, consumer protection laws also cover matters of conscience. And if you as a Canadian care deeply about something that doesn't affect your health and you're lied to, you can take action under the federal law. So I think that was a very important part of the decision. And that'll have implications going way beyond this particular dispute.
Correct.
Justice McTavish here, correct me if I'm wrong, but distinguished from the Richardson decision in the United Kingdom.
Yes.
On the need for consumers to be able to take conscious decisions about what they're consuming.
I couldn't disagree more with the Richardson decision. This is a UK court which essentially held the circumstances were rather different here. There wasn't a complaint by a consumer about false labels, but somebody who had taken action pursuant to the BDS movement was charged criminally, and then invoked this idea that these products had been mislabeled, and the UK court rejected this argument with rather flimsy reasoning, with all due respect. But interestingly, 3 months ago, this very same winery, I mentioned there were two wineries. One was Psagot, commenced litigation in Europe. It wasn't 2 months ago they commenced it. It was a couple of years ago. And because the European Union issued guidance, a regulation stating that the West Bank settlement products had to be labeled as being from settlements.
Yeah, correct. So I have a summary of that. Yaakov Berg, the wealthy Israeli owner of Sagot Winery, wants to cancel a 2015 imposed EU regulation that requires member states to specifically label products as coming from Israeli settlements in the West Bank rather than Israel proper.
Yes.
So that a little bit of a reversal of
Correct. And so what does Yaakov Berg, the CEO of Psagot, do? And by the way, the European authorities, by and large, were not enforcing this regulation. They were allowing the products, they were just ignoring it. They were allowing settlement products to be labeled as product of Israel. But Yaakov Berg, because he is quite frankly a fanatic in terms of his beliefs, decided he was going to go and challenge the regulation anyways, even though nobody was enforcing it. And initially, he succeeded in persuading a French court that the regulation was invalid. But then the matter went up to the European Court of Justice. And 2 months ago, the Advocate General, whose advisory opinions to the court are usually followed by the European Court of Justice, ruled that in fact the regulation is not only valid, but that the European Union has an obligation under international law to ensure that these products are accurately labeled. And in that decision, the Advocate General criticized the decision of Richardson in the United Kingdom, I think quite rightly.
From what I read, Advocate, so that would be in June of this year, Advocate General Gerard Hogan did not mince his word. He recommended that the EU keep the regulation, saying that the settlements are a manifest breach of international law. I'm not saying it. You're not saying this. It's the Advocate General.
Correct. But so has the United Nations Security Council repeatedly.
International Court of Justice.
Unanimously. I believe it was 14 judges. Even the American judge agreed that the settlements violate the Fourth Geneva Convention, the International Red Cross, the General Assembly. I mean, on and on and on. Human rights organizations such as Human Rights Watch, Amnesty International. This is not. Michael Link said something which I think is quite appropriate. The UN Special Rapporteur for Human Rights, who's a Canadian law professor. He said, those who say that the settlements are not a violation of the Fourth Geneva Convention are propounding a theory that is equivalent to the theory that the earth is flat. That's how ridiculous it is. It is absolutely crystal clear. And that is why the Canadian government has agreed that the settlements violate the Fourth Geneva Convention for decades. Even Stephen Harper's government, the most pro-Israel government Canada has ever had, did not waver from the position that the settlements violate the Fourth Geneva Convention.
Let's go back to the case.
Sorry.
No,
It's wound up.
No, it's fun. No, not at all. Les questions en litige. We had la norme de contrôle applicable. Sorry, you argued that it was la norme de contrôle de l'édition correcte, and the judge disagreed with you. It would have been la norme de contrôle de la décision raisonnable. So in our case, we have to remember that it was an administrative body who rendered the decision. So we need to, as an expert court, you said, well, that should be la règle de la décision correcte.
Right.
So why did you go there? Was it because it was the easier argument?
Certainly it's an easier standard for the complainant to have to meet, no doubt about it. But the basis of the argument was that, and the record in this regard was absolutely clear. The government submitted in opposition to our judicial review application an affidavit from the official in the Complaints and Appeals Office who had dealt with us when David Kattenburg complained, and he was cross-examined. And one of the things that we learned was that the CFIA did not actually make the decision that these wines were properly labeled. What happened was it deferred completely to Global Affairs Canada. And somebody who very high up in the Privy Council's office told the CFIA that the Canada-Israel Free Trade Agreement essentially enabled or authorized these products to be labeled as product of Israel because of the way it defined Israeli territory for purposes of the agreement.
So excuse me. So you, in the cross-examination of the gentleman who oversaw the complaint, you learned that not only it was not enforced, but it was actually correct to label these wines as Israeli wines.
What his testimony was that we when
and
it comes to
you're not quoting. You're going
no, I'm
out
paraphrasing.
of exactly, and you're going out of memory as well. But
but I don't think the government would dispute this. I'm quite confident about that. His testimony was the CFIA was in no position to decide whether or not the West Bank is properly called part of Israel or not. They sought guidance from Global Affairs Canada, and they were entirely dependent upon the decision of Global Affairs Canada in that regard. So when Global Affairs Canada came back to them and said, well, yes, it's true, we do regard the settlements as a violation of the 14th Geneva Convention. We do not regard the West Bank as part of Israel, but there's this clause in the Canada-Israel Free Trade Agreement which makes this all fine. The CFIA simply took the word of Global Affairs Canada. So in fact, it was not the tribunal, this was our argument, it was not the administrative tribunal which made the decision, it was Global Affairs Canada which made the decision. And so why should you defer to the expertise of the Canadian Food Inspection Agency? It simply wasn't employed in this case. And so the judge, as you've noted, did not agree.
Did you change your argument midway after cross-examining the guy?
Well, I think we had indications early on. It had become reasonably clear before the cross-examination that the CFIA had relied upon Global Affairs Canada. In the cross-examination, he confirmed it. And so that's the point at which we decided to make this argument that the standard of correctness should apply and not the standard of reasonableness. But as you noted, even though she rejected that argument and applied the standard of reasonableness, she nonetheless found in favor of Dr. Kattenburg because this was a patently unreasonable decision. Nobody says the West Bank is part of Israel, not even Israel. So how can you say that a product of Israel label on a West Bank wine is truthful?
So even with the higher standard, the court still rejected the defendant's argument.
Right.
What's happening with those wines today?
Well, subsequently, actually about 3 weeks ago, Psagot Winery had made a motion to be added as a party to the appeal because the Attorney General is appealing the decision of Justice McTavish. And in its supporting materials, an affidavit from its CEO, Yaakov Berg, this individual you mentioned a few minutes ago, he says that they're no longer exporting their wines to Canada. They stopped after Justice McTavish issued her decision, only in Canada. As far as I know, Psagot continues to sell its wines in Europe and the United States and Russia.
So his argument is what now? An economical argument? He's losing money? Or is that the argument? I'm just not sure. I'm sorry.
The argument is that they should be allowed to participate as a party in the appeal because they are directly affected by the decision. And the reason why they're directly affected is A, they're losing sales, and B, the reputation of the winery has been damaged because Justice McTavish said they were using false.
So that's the reason for his intervention, but we don't have his position yet on the actual case.
I think we've gotten a preview of their position from his affidavit. His affidavit suggests, the argument he puts forward in his affidavit is that the settlement is governed by Israeli law, and he provided a licensed dealer's certificate for Psagot Winery issued by the Israeli taxing authority. And he said the people who produce the wine are Israeli nationals. And so because it's made by Israelis in a settlement that's governed by Israeli law, it's reasonable to call it product of Israel. I think that that's going to be the argument if they're allowed to participate.
I'm just going to, from the top of my head here, last time I went to California, I think they're all Frenchmen making the wines over there.
That's precisely the argument we'll be making, amongst others, in response if they are allowed to take part. The issue here is not who's making the wine. I mean, do you as a wine producer, if anybody who knows about wine isn't going to give a damn whether the wine is made by somebody from one country or somebody from another country.
As long as he's a good winemaker.
Exactly.
Yeah.
Does the person know how to make wine, and what are the characteristics of the terroir where the wine is made? Mm-hmm. And in fact, if you go to the Psagot Winery website, they talk a great deal about the very unique, peculiar, and beneficial aspects of their terroir. And you as a this is what you want to know if you're buying wine. You don't really care what the nationality is of the person who's making the wine. So the argument, frankly, is, from my perspective, quite a stretch.
How long was the hearing?
2 days.
2 days. Again, I'm going to go back to what I was saying earlier. Why did it take such a big envergure? Yes.
Right.
Why are we talking about this? I'm sorry. I'm sure there's a whole bunch of labeling issues and lawsuits left and right. Why did this one? It's not a very big case in a sense that it seems to be very straightforward from the decision. I'm not saying this, you're not saying this. Mm-hmm. The decision basically says, okay, who here says that the wines are made in Israel? Nobody? Okay, good. So then they're not made in Israel. That's basically what we have here. Mm-hmm. So why did it take such proportions? Yes. Thank you, James.
You can't answer that question without understanding what the agenda of the Israeli government is. In the partition of Palestine in 1948, 2/3 of the territory of historic Palestine were given to the Jewish population, which constituted a minority of the population at the time. The majority population, Palestinians, got only approximately 1/3 of that land. And ever since then, the state of Israel has been pushing to confiscate the rest of it. And calling the settlements product of Israel, for the state of Israel, for the government of Israel, is a very important part of that project.
Okay, so this is, and pardon me, Dimitri, but this is one. I'm sure I can get somebody else sitting here who's going to say a different vision. Okay, but I'm asking you, legally speaking, what is the implication to have more products with Israeli label on it sold? Is a Israeli wine better than a West Bank wine? And is that labeling so important to have such a legal implication? I'm sorry, I don't understand basically what's the point on a legal basis. Like we read and we reread, and basically, the federal laws that I named, they're one article. So Article 5, one, Article 7 of the other, and that's it. It's fairly clear.
Yes. It should be a very simple decision with that passes unnoticed by the public, frankly. That's what it should be. But because it runs counter to the fundamental political objective of a country but the Canadian government deems the state of Israel to be an important ally. It values, rightly or wrongly, the relationship with the government of Israel very highly. And this decision undercuts a very important, in fact, I would say the overarching objective of the Israeli government ever since the creation of the State of Israel.
What's the alternative? We say we don't care about labels anymore. Do you understand? I think that the negative of that decision is way, way, way more dangerous than this decision right now. And then after that, I can say, oh my God, I'm going to have olives in my backyard. I'm going to say Greek olives.
Yeah.
Maybe because you're Greek, maybe you can help me harvest them. I don't know.
Listen, if this decision, what you're saying is very important. If this decision is overturned and the Canadian government has its way, that's going to open up the door. It's going to open up a true Pandora's box. You mentioned earlier that one of the instruments we invoked in court was the United Nations Charter. Mm-hmm. The foundation of the United Nations Charter, which was developed out of the ashes, the destruction, the horrors of Second World War, is the prohibition against the acquisition of territory by conquest. The international community said you cannot acquire territory by conquest because we're just going to be encouraging all sorts of devastating wars if we allow that to happen. And Israel is effectively trying to acquire territory by conquest. It conquered the West Bank in the 1967 war. And so if this decision stands, whenever a country acquires territory by conquest, begins to transfer its own population into that country, then the merchants, the people who do business from the occupier going into that occupied territory will now be able to present their products as being products of the country that is occupying this territory. It is basically an assault on the prohibition against the acquisition of territory by conquest. That's what the Canadian government's position is. It goes to the very foundation of it may sound, hyperbolic, but it isn't. It really is an assault on this fundamental principle of international law, the bedrock principle of international law. And I think Canadians should be very concerned. Whatever they may think about the Palestinian people and their plight, they should be very concerned about where this will lead us and how this is going to affect respect for international law.
Are the factums in appeal filed?
No, they'll be filed I would imagine, in the first quarter of next year.
First quarter of next year. So, and the hearing should be next year as well, or?
Yes.
And what happens other than having those two wines out of the shelves? Anything else happen?
Well, if this decision stands, there are a lot more products being sold in Canada from the settlements than these products. There are all sorts of products being sold in Canada.
That we're just not aware, or?
Oh, we are aware of a number of them.
Okay.
I think our last count was there are 17 just wines. There are lots of other types of products coming out of the West Bank. There are 17 wines being sold in Canada across the country from occupied territory occupied by the State of Israel, that are being represented as product of Israel. And so all of these products that have labels of product of Israel on them that are coming from occupied territory are going to have to be relabeled if this decision stands, and that's exactly what should happen. They should be relabeled.
Tell us a little bit about the procedure in Federal Court of Appeal. So is it regular appeal? So there's not going to be any testimony? There are not going to be any witnesses heard? Am I correct?
Yes. Okay. It should be based entirely on a paper record,
Mm-hmm.
and it should be based on the existing paper record. But as I mentioned, Psagot Winery is seeking to be added as a party, and what they want to do is to file fresh evidence. So if they are allowed to do that, then the evidentiary record may well change quite significantly.
Okay. And what is the possible outcome?
It was an application.
Okay.
So, again, assuming that Psagot is not allowed to put new evidence to the record, we will be going in front of a 3-judge panel of Federal Court of Appeal with exactly the same evidentiary record as Justice McTavish had to consider. And we'll make our arguments, and after that, if there may well be an attempt to appeal this to the Supreme Court of Canada, it wouldn't surprise me at all if we end up there one day.
Psagot wine, one of their argument in UUK. So in all the maps of the world for 3,000 years, it has been written that here, the West Bank, is Israel. Everyone knows where Israel is. So that's one of the arguments. So are we expecting this?
First, yes, I think we're going to hear that argument if Psagot is allowed to become a party. First of all, I don't think that's true. If you look at lots of maps, what you'll see is Palestine. That's what it was called for a very, very long time. But let's suppose for a second that Yaakov Berg has a point, and I don't dispute this. I don't dispute at all that the Jewish people have a very important bond to Jerusalem and to other parts of what was historic Palestine. And I'm quite prepared to acknowledge that there has been at least some continuous presence of the Jewish community in what is now Israel today in the West Bank for centuries, absolutely. But that doesn't entitle people who are returning to Israel to dispossess the Palestinians of their land by force and to render them stateless. So to give you an example, something that's close to home to me as a Greek, okay? For centuries, Greeks lived in what is today Eastern Turkey. And in fact, Istanbul was once known as Constantinople, and it was the seat of the Orthodox religion. Mm-hmm. And in fact, I have good reason to believe that my ancestors came from Constantinople, what is today Istanbul. It never even occurred to me that I, as a Greek, can go back to Eastern Turkey or Istanbul and dispossess Turks of their homes because I have some ancient connection to this land. If you accept that reasoning, this world is going to descend into chaos and violence before you can blink an eye. And, that'll be the end of human civilization. There is a legal architecture which the powers of this world put in place after the Second World War to diminish the threat of war and the horrors of war, and we have to respect that legal architecture if we want to preserve human civilization.
Okay, so I'm glad that you said legal architecture, because you understand that we went to end of civilization with labeling of wines, so it's a fairly big stretch.
The immediate issue is not going to bring an end to human civilization. The disrespect for the prohibition on the acquisition of territory by conquest will threaten human civilization. If we disrespect that principle, it's extremely dangerous to fail to respect this fundamental prohibition that is the bedrock principle of international law. This is something that Canadians on the surface may not be persuaded merits their attention, but when they understand what's at stake, I think they should care very deeply about it.
Correct. All right, so let's take a small break and gather our thoughts. We're going to go into something maybe again controversial with you okay. after the short break. Thank you, Dimitri Lascaris.
Thank you.
Cette annonce vous est présentée par Rivercast Media. Je suis avocat en pratique privée et j'ai toujours eu de la difficulté à trouver toutes mes heures de formation dans un temps et dans un format et pour un prix qui m'était raisonnable. Pensez à optimiser votre temps et votre argent en vous abonnant au podcast Question de Preuve. Sur votre plateforme de podcast préférée, Apple, Google, Spotify, recherchez simplement Question de Preuve et cliquez sur le bouton S'abonner ou Subscribe. Vous pourrez ainsi écouter tous les épisodes gratuitement directement sur votre téléphone intelligent dans la voiture, au gym ou pendant votre heure de lunch. De plus, vous y verrez apparaître automatiquement les nouveaux épisodes dès leur sortie, sans aucune intervention de votre part. Pour les juristes qui nous écoutent, vous abonner à Question de Preuve, c'est aussi une façon d'obtenir toutes vos heures de formation continue pour aussi peu que 300 $. En effet, notre promotion d'automne vous permet de profiter d'un tarif équivalent à 10 $ l'heure de formation. Reconnus par le Barreau du Québec et la Chambre des notaires du Québec, nos formations en podcast vous permettent de réaliser vos heures de formation tout en relaxant à la maison, lors de vos déplacements, en vous entraînant au gym et pourquoi pas en promenant votre chien. Vous trouverez tous les détails sur notre site internet rivercastmedia.com/question de preuve. Abonnez-vous, rivercastmedia.com, question de preuve. Back with Dimitri Lascaris, attorney and activist, and you're now gonna take us to another important part of certain lawyers' practice, which is the navigating between media and controversy, being a lawyer and being an activist. First of all, what is your suggestion to lawyers who are being interviewed, where the journalist is kind of sometimes, I guess, confusing the fact that you're an activist and that you're a lawyer? In our particular case, it was a labeling case. Mm-hmm. It was not necessarily to its face to a courtroom an activism case. Mm-hmm. It was based on justice and based on law. So what do you say when a journalist comes and asks you questions that are maybe on the line between they want to get a juicy story as an activist mm-hmm. and the fact that you're actually an attorney representing a client?
It's a very it's a difficult balancing act because on the one hand, we as lawyers are taught that we're not supposed to be arguing our case in the press. The place to do that is the courtroom. But on the other hand, we also have to be mindful of the fact that in order for the work that we do as advocates for human rights causes or whatever it may be that we're advocating on behalf of, our ability to make a difference depends upon the public being made aware of what is happening in the courtroom. And so, the way I try to strike that balance is when I speak to the press about the things that I'm litigating that the press takes an interest in, I try to make sure that I note what the other side's arguments are. Don't misrepresent the evidence. Don't misrepresent. Be very careful about that. Be very careful about accurately representing what the position of your adversary is. Be very careful about stressing that the final decision will rest with the judge, and as it should. But at the same time, I think I feel an obligation as an advocate who's working in public interest matters to make sure to do everything that I can to make the public aware of what's happening in the courtroom. And so when I get asked by journalists about this, I mean, some lawyers will just flatly refuse to talk to the media about anything that's pending before a court. I think that that's, an overly cautious approach. I think, if it's a matter that engages the public interest, then you should be willing to talk to the media. But at the same time, you have to be very careful to be faithful to the facts and to the law and to your adversary's position.
What about when you are attacked and you find out in the media that you've been attacked? It happened to you.
Yep.
Well, we can call it an attack. You've been characterized, let's say.
Sure.
I'm not sure if we can call it an attack, but and you learn in the media. What do? You respond in the media? And I've been with respect to this particular issue, my advocacy for Palestinian rights, I've been attacked many times in the media. Some very nasty things have been said about me in post-media newspapers, the National Post, the Vancouver Sun, the Toronto Sun has said horrible things about me. The way I deal with those things is in an appropriate case, I will pursue a defamation litigation. And I've done that actually in one case. It wasn't a media organization. It was this advocacy group that I've mentioned, B'nai B'rith. They accused me of being a supporter of terrorism. And so I pursued a defamation claim against them, and that's currently winding its way through the courts. Most of the time, however, that is not my preferred course of action because, first of all, it's not easy to prevail on a defamation claim, especially if you're talking about a matter of public interest. It's very difficult, but also it's very expensive, very time-consuming, and I prefer to respond to these attacks with logic and reason and try to persuade the public that they're unfounded. And the worst case was, I was attacked by the Prime Minister of Canada, Justin Trudeau, who said some very nasty things about me because I criticized two members of his caucus who were very, very pro-Israel. And those two members of his caucus happened to be of Jewish ethnicity, but that had nothing to do with the reason why I criticized them. I criticized them because of their advocacy for the state of Israel, despite Israel's human rights violations. So I decided in that case, I'm not going to take on the Prime Minister in a defamation claim. I don't think that that's going to be a particularly useful expenditure of my time and money. But I have responded publicly, and I've been defended by members of the Jewish community from his accusation, and I'm forever grateful for their support. And I think that in that case, that's the better way to go. So how does that work? When you're attacked by the Prime Minister, I guess you get a phone call from a journalist, or you call the journalist yourself and you defend yourself publicly?
I've never, in these circumstances, had to pick up the phone and call the journalist. I mean, when you're attacked by somebody like the Prime Minister, inevitably the calls are going to come in. So,
do you consult with attorney PR firms in any way for?
I mean, when I was a securities lawyer, when I was a class actions lawyer, at the very beginning of my career, I actually got some training in how to deal with the media. That was within the first year or two of my practice. After that, I never consulted, or maybe once or twice on some big cases, some class actions. In the context of this work that I've been doing since I left the class actions practice, no, I think I just sort of rely upon what I learned in the course of being a class actions lawyer about dealing with the media. And it is very important to understand as a lawyer how the media works. Very, very important.
So your suggestion would be to get some kind of a formation, some kind of a
absolutely if
training on media relations.
If you believe that the media is going to take an interest in the work you're doing, then it is really important to not just understand how to respond to questions, but you have to understand how journalists operate and the pressures under which the pressures with which they must deal, their deadlines, their editorial pressures, financial considerations. And once you get inside the head of a journalist, then you can avoid making the kinds of mistakes that can get you into hot water as a lawyer.
That's interesting. I'm not sure what kind of cases I can get as a commercial litigator that would get me in the hot water the way it seems to get you.
I don't think you'll attract all the press attention. The kinds of cases you...
Dimitri Lascaris, last question regarding the labeling case. If there would be something you would like to redo or do differently, what would it be?
Well, I would really like to have some information came to light recently that I would really like to have before the court, and that is that one of these wineries, the Psagot winery, has been built, and there's apparently quite significant evidence of this, which I only learned of about 3 months ago, on land that is privately owned by Palestinians, and it's just been basically stolen. And the illegality of that is so flagrant that the Israeli government apparently has issued a demolition order against the house of the CEO of that winery, Yaakov Berg. And the demolition order has not been implemented in over 10 years, but nonetheless there is a demolition order because of the illegality. So if I could do it differently, I would get that before the court, and I'd also get testimony directly from Palestinians themselves who have been dispossessed of their land as a result of this winery.
So it sounds more like a wish. So would you so I'm going to ask you the same question but differently. So are you telling me that you should have done more investigation?
Well, no, I think we have a more than adequate evidentiary record, but I think it could be better. The problem is we're dealing with a part of the world where, I don't speak the language. The legal system is very different. We had very limited resources. As I said, I'm doing this pro bono. David Kattenburg doesn't have the ability to hire investigators and to dig up archival material in West Bank and Israel. So we had to deal with those limitations. But yeah, in an ideal world, I would like to have that evidence in front of the court.
Economic limitations are part of most lawyers' regular practice.
Absolutely.
It's very rare that you're going to have unlimited funds and unlimited resources to investigate and to get the proof prior to trial.
Right. And this is one of the big, one of the very serious flaws in our justice system is that there is frequently a grotesque imbalance in the resources of the litigants. And you'd be fooling yourself if you didn't think that affects outcomes. It has huge, when you have going up against a public company that has $500 billion of market capitalization, can afford to hire, the 10 best experts in the relevant fields. And
forget about hiring them, just put them on retainers so you cannot have access to those
I can't tell you how many times that's happened.
Yes.
And, your client is a small investor who lost $3,000 and has a mortgage on his, $200,000 home. To think that is not going to affect your ability to win is naive. It does. And so we're seeing consistently every day in this country, and it's not written about, it's happening every single day in this country, litigation outcomes that are not just because of the imbalance in the resources of litigants.
It's not particular to this country, however. You've worked in New York, must have been...
Even worse. Except the one thing about the United States, I must say this about the U.S. legal system, is they don't have adverse costs. So if you as a litigant take on a large corporation and you lose, you don't have to worry about having to pay a $500,000 cost award to the corporation. That is a huge deterrent to small investors or others, consumers who have been injured by corporate misconduct, trying to get relief through the court system, the threat of an adverse cost award.
What would be your solution to this?
I think in certain types of cases, there should be no costs, absolutely none. I also think that lawyers need to make less money, frankly, and they should be forced to devote a very significant amount of their time to doing pro bono work.
In Ontario, the costs, are they based on percentage of the file? Or how
yes, usually the court will award what's called partial indemnity costs, which is probably in the range of about 20 to 40% of the actual costs of the winning litigant.
Okay.
So, there have been cost awards in class actions that have exceeded $1 million. Given against plaintiffs in class actions. So
we don't have that in the Code of Civil Procedure anymore.
Mm-hmm.
However, I've heard that it's still being negotiated in some cases.
Well, Quebec has, on the whole, the Quebec legal system is in my experience, much more evenly balanced as between
I agree.
poorly resourced litigants and large corporations.
Yeah.
Absolutely. I wish we in Ontario would move in that direction.
Agree,
and then substantive law, like the Consumer Protection Act in Quebec, is wonderful relative to the other provincial acts. There's very strong legislation, so a lot can be done by our legislators in that regard.
All right, Dimitri Lascaris, last segment of our show is I always ask the same question to every guest that I have. I usually get a light answer. I'm not sure what I'm going to get from you today. Item, a tool, a a book, anything that you use professionally, I would say every day, or that you cannot do without. Would you have an item, a tool, anything like this that you would share with us? Some people share their iPhone. It's been done, so just so you know.
Very original.
Yeah, well, he's got a case against Research in Motion, so I'm pretty sure he never had a BlackBerry.
I did actually.
You did.
I jettisoned it after that case, but so it's not really like a physical thing. I have a very, it's an embarrassing habit of articulating arguments out loud constantly. And so I find myself oftentimes I'll be walking in the street and I'll be
talking to yourself.
Yeah, absolutely.
It
I get caught all the time
these days because everybody has those like wireless headsets.
Yeah, but I'm not wearing a wireless headset when I do it. So that can be quite embarrassing. I'm sitting here articulating, arguing things, right? Whether you're doing it written or in oral is a craft, and you can constantly improve the quality of your argument. So I do that by talking out loud, and it can be quite embarrassing. But I honestly can't imagine not doing it because it's such an important, for me, it's such an important method for making my arguments as effective as possible. So I really, other than that, I can't.
No, that's actually very good. It's like you've surprised me again, Dimitri. I thought we were going to come with something.
No, I don't have anything profound to say. I'm sorry.
No, that was profound. That's better than an iPhone.
Yeah, not when it happens to you. Believe me, my kids are constantly horrified that someone's going to go up to say, your father's always talking to himself in the street. I mean, is he losing his mind or something? But anyways.
Alors, de mon côté, cette semaine, c'est pas un outil que je me sers constamment dans ma pratique, mais je vous invite à consulter le site du ministère de l'Agriculture, Pêcherie et Alimentation Québec, la MAPAC, sous l'onglet Conseils pratiques, étiquetage des aliments. Tous les produits préemballés doivent porter une étiquette. Celle-ci permet de connaître le nom et la nature du produit, la date limite de conservation, la liste des ingrédients et de leurs constituants par ordre décroissant d'importance, la quantité, l'origine du produit, le nom et l'adresse du fabricant, l'état du produit, par exemple, lorsqu'ils sont décongelés, les viandes, les produits marins et leurs sous-produits doivent porter la mention « produits décongelés ». Certaines étiquettes peuvent aussi préciser la date d'emballage, le mode de conservation, le numéro de l'eau, la valeur nutritive. Donc, ça nous donne une bonne idée. Et là, lorsqu'on est sur ce site-là, il y a aussi une version mobile sur la sécurité des aliments. Donc, si vous allez sur la version mobile, vous avez une carte qui peut vous aider à trouver les condamnations des établissements alimentaires qui ont été condamnés par la MAPAC. Et il y a aussi une liste de rappels d'aliments. Dans le même ordre d'idée, je vous invite aussi à consulter le site de l'Agence canadienne d'inspection des aliments. Et il y a une trousse d'outils pour les entreprises alimentaires. Donc, aux juristes, là, vous pouvez dire à vos clients d'aller consulter la trousse d'outils pour les entreprises alimentaires qui est produite par l'Agence canadienne d'inspection des aliments afin d'aider les clients à se conformer au règlement sur la salubrité des aliments au Canada, qui s'applique généralement aux entreprises alimentaires qui importent des aliments ou conditionnent des aliments à des fins d'exploitation ou de commerce, notamment interprovincial, puisque c'est le site fédéral. Toutefois, certaines exigences en matière de traçabilité, d'étiquetage et de publicité s'appliquent également aux entreprises alimentaires qui font du commerce intraprovincial. Donc, il y a des tests pour découvrir si l'entreprise doit se conformer à des nouvelles exigences, savoir s'il faut obtenir une licence, si on doit obtenir des registres de traçabilité et si l'entreprise doit établir un plan de contrôle préventif. Donc, le site de l'Agence canadienne d'inspection des aliments est une excellente source aussi en lien avec ce dont on a parlé aujourd'hui et qui va certainement pouvoir aider votre clientèle. What's next? I know there's the appeal. I understand you've been retained as the attorney for the appeal as well.
Right.
Any conference, books, any appearance, anything coming up that you want to share with us?
Well, we may be in court again on a similar issue, but this time involving a Palestinian producer of beer who is being prevented from using product of Palestine labels in Canada. So stay tuned for that one. Hopefully we won't have to go to litigation, but it's possible.
All right. And if we want to follow you or reach you, I think you have your Twitter handle, which is Dimitri Lascaris.
Correct.
Is that a good way to follow you and follow your...
Yeah. I'm probably too active on Twitter, actually. So, yeah, that's if you're interested in, the cases I'm working on, I guess you could do it that way. Sure.
Great. Dimitri Lascaris, thank you very much for coming over and sharing your experience with our listeners at Question de Preuve.
Je vous en prie.
Thank you.
But look, I really appreciate you inviting me here, and it was been a pleasure talking to you.
Je vous remercie de votre attention. Le mot-clé pour cet épisode est « territoire ». Il sera nécessaire pour obtenir votre attestation de formation continue dans la section « Questions de preuve » du site rivercastmedia.com. Je suis ouvert à vos commentaires, suggestions et idées. Contactez-moi pour venir discuter de sujets qui vous concernent, qui vous tiennent à cœur, qui font avancer la pratique du droit et qui favorisent l'accès à la justice. Les détails sont disponibles sur le site rivercastmedia.com ou sur notre fil Twitter @questdepreuve. Mes prochains invités confirmés sont Jean-Sébastien Damour en droit de la santé, Jean-Philippe Lincourt sur les actions collectives et Emmanuel Saint-Aubin en droit immobilier. Notre prochain épisode qui sera publié concernera la commission d'enquête sur les relations entre les Autochtones et certains services publics au Québec, Écoute, réconciliation et progrès, présidée par l'honorable Jacques Vien avec Geneviève Richard et Sébastien Brodeur-Girard. Nous avons un épisode sur l'AAP 2019 qui sera bientôt publié. Être bâtonnier dans la trentaine avec Maxime Alpin et Alexandre Forêt, une mise à jour sur les activités du Barreau du Québec avec Paul-Mathieu Grondin et Wagner avec le juge en chef du Canada. Restez à l'affût de Rivercast Media pour le lancement prochain de la série judiciaire Innocentia. Quant à moi, je suis @HRMartin sur Twitter. Abonnez-vous à Question de Preuve sur Apple Podcasts, Google Podcasts, Spotify ou n'importe quelle application de balado. Évaluez-nous sur Apple Podcasts. Sachez que vous pourrez sous peu rechercher sur Google le contenu de nos épisodes en format plein texte. Je vous invite à cliquer « Subscribe » ou « Abonnez-vous » sur vos applications de podcast. C'est bon pour que Question de Preuve soit reconnue, soit augmentée ou ait une meilleure visibilité dans les applications de balado. Et en même temps, ça va favoriser la mission de Question de Preuve, c'est-à-dire faire avancer la pratique du droit et promouvoir l'accès à la justice. Restez à l'écoute des prochains épisodes, nous allons accueillir d'autres invités de marque. Idée originale, animation, réalisation et montage, Hugo Martin. La musique et les clips audio sont de René Gagnon. À l'équipement audio, Sergio Travaglione de Musique Red One. À la recherche et à la réalisation, James Patrick Cannon. À la gestion, au marketing et à la direction générale, Constance Saint-Pierre. Ce podcast est une production de Rivercast Media SA et rappelez-vous, tout est question de preuve.